Late breaking news, and reporting from Richmond, at this hour, while the legislature had recently embraced the desires of Virginia voters, enacting a provision to permit voters to express their individual preferences for candidates with ranked choice voting, at least for now, two preferences of voters remain hidden behind a veil of judicial secrecy and prosecutorial immunity, as two cases make their way to the Virginia State Supreme Court, the appellate court of last resort for civil litigation in the Commonwealth of Virginia. The first matter dates back to November 2022 in the Virginia courts, when one litigation hobbyist and former childhood protege of a legendary civil rights and criminal defense attorney had quietly filed a sworn affidavit with the Commonwealth's attorney for the city of Alexandria, Brian L. Porter, detailing a specific and articulable statement of probable cause that the incumbent legislator in Virginia's 8th congressional district, Donald Stern of Beyer, had been implicated in the offer of a bribe to a congressional candidate during the 2016 election to persuade him, in quid pro quo, to withdraw from the election contest, in which Congressman Beyer had been the heir apparent to ascend to the U.S. Senate. Had Virginia Senator Tim Kaine been successful in ascending to the office of the vice president with former Democrat Party presidential nominee Hillary Clinton, who had also been Beyer's former boss at the State Department, when he had served as U.S. ambassador to Switzerland and Liechtenstein. The Alexandria prosecutor has advanced a novel interpretation of prosecutorial discretion on record, and in one previous case had actually filed pleadings with the Alexandria Circuit Court, under penalty of sanction, that, even if there was probable cause that the Alexandria mayor, Justin Wilson, his fellow Democrat, had committed cold-blooded murder and heinous acts of terror, no lawful authority in the land could compel him to do anything at all. In this action, commenced in the courts as Webb v. Porter, case number CL24001532, is now on appeal at the state Supreme Court, after the prosecutor had successfully blocked a matter brought on mandamus to compel a grand jury investigation, using a preemptive pre-filing injunction that Prosecutor Porter had filed in a similar prior case. Shortly after that litigation commenced in the city of Alexandria, the mayor, a Democrat Party rising star, most abruptly, decided not to seek re-election in December, followed by the sudden decision of the presiding judge, the Honorable James Clark, to announce his retirement from the judicial bench. That matter now remains on appeal in Richmond at the state Supreme Court, Webb v. Porter, record number 240465, since May 27, weeks before the June primary elections, and, with an important presidential election that finds the 13 electoral college votes in the battleground state of Virginia up for grabs, both the court and Alexandria prosecutor, Brian Porter, a former Jeopardy contestant, and graduate of the Night Division at George Mason University Law School, electing a dubious right to remain silent. In December, the 73-year-old legislator had announced proudly and boldly that he would be seeking re-election in 2024 to a sixth term as representative for Virginia's 8th congressional district, and, to date, has raised and disbursed over $1.5 million, with the battle cry message of most appeal to voters in this D+26 congressional district, promising that he will do all he can in 2024 to prevent would-be dictator Donald Trump from getting anywhere near the White House. And, at least that was before an action had been filed in Alexandria Circuit Court to compel the convening of a grand jury investigation into serious allegations implicating the senior legislator in a bribe offered during the 2016 election, when Congressman Beyer had quixotically even told the Washington Post, "Conventional wisdom says this is a Democratic seat, but conventional wisdom is often wrong, so I'm taking nothing for granted." That matter was quickly quashed quietly in the Alexandria Circuit Court, but now remains on appeal at the state Supreme Court, and the Alexandria prosecutor, Brian L. Porter, at least for now, is also electing a dubious right to remain silent, especially after his claim, explaining his understanding of his prosecutorial discretion, arguendo, when accepting that probable cause exists. No court can order the Commonwealth attorney to charge anyone, and, His decision to charge is a discretionary duty that lies entirely within the province of the public prosecutor. Now, that claim is before the state Supreme Court, and Commonwealth's Attorney Porter, a former Jeopardy contestant, who had run unopposed in his last election, but capturing only 93% of the vote, has, thus far, been reluctant to follow up with a legal brief to explain that, in the form of a legal argument. Apparently this game show during a presidential election yet does not find him with quite the confidence he had displayed when boasting that he would punish the competition and put heads to sleep when trying to provide a response in the form of a question with Alex Trebek. Meanwhile, in the county of Arlington, a George Soros finance prosecutor, Parisa Danyani Tofty, after an easy unopposed re-election just last year against any Republican, despite the enormous number of licensed and practicing attorneys in Northern Virginia, and after defeating a nominal challenge in her own party primary, going on to run unopposed in a community where Arlington Democrats hold all of the strings of power, is only now tiptoeing carefully through the potential minefield, while Major Mike Webb, an independent, and not even a licensed attorney, is thrusting forward with guns a-blazing, having filed a similar affidavit regarding the pandemic response of the second-best public school district in Virginia. A Freedom of Information Act response has disclosed that public school officials had wholly ignored an order in June 2020 from the State Health Commissioner, Dr. Mohammed Norman Oliver, to develop a plan for the safe reopening of public schools and, in the Commonwealth, any parent, custodian, or legal guardian of a pupil attending the public schools in a school division who is aggrieved by an action of the school board may, within 30 days after such action, petition the circuit court having jurisdiction in the school division to review the action of the school board, which statute of limitations has told long before now on the COVID-19 response at the Arlington Public Schools, as Virginia Public Schools, after 2 years of cancellation of in-person instruction, today find themselves ranked 6th nationally for learning losses, an issue not even discussed by candidates running for the local school board. Under the controlling law, had that judicial review occurred, it would proceed upon the petition, the minutes of the meeting at which the school board's action was taken, the orders, if any, of the school board, an attested copy of the transcript, if any, of any hearing before the school board, and any other evidence found relevant to the issues on appeal by the court, and the action of the school board shall be sustained unless the school board exceeded its authority, acted arbitrarily or capriciously, or abused its discretion. Yet, even upon a presentation of these facts to the Arlington County Prosecutor, George Soros finance Parisa Danyani Tofty has also elected a right to remain silent, especially during an election year, because, apparently, victory at the polls has subordinated the civil rights of almost 30,000 pupils in public schools, in a district that spends more per pupil, over $20,000, than any suburban public school district in the greater capital area. That matter, Webb v. Danyani Taffet, Civil Action Number 01324000745002, had been subject to a preemptive pre-filing injunction, and had been immediately dismissed by the Arlington Circuit Court, and is now, too, on appeal to the state Supreme Court since June 24. Webb v. Danyani Tofty, record number 240599, while the prosecutor has elected a right to remain silent. Clearly, if Arlington parents love their children more than voting for their candidates, in this action, it is quite empirically not a parent in action. Stay tuned for more late-breaking election news as we continue to follow up on this developing story.
This message was approved by Major Mike Webb. Honest. This has been a Filmways presentation, darling.
And y'all come back now. Yeah.